Okay, well, we're back for a question and answer session. We didn't really have the time to do it, unfortunately, on Tuesday night. We had so much good material and so many good speakers to hear from. We just ran out of time to cover the questions that so many of you put into the Q&A function of Zoom. So one of our speakers who generated the most questions, Professor Adam MacLeod at Faulkner University School of Law, author of The Age of Selfies, has graciously agreed to rejoin us for sort of a follow-up Q&A session. And I'm just going to read to him a handful of questions that we got, because they were sort of triggered by some of the material he was discussing, and then we'll weigh in on it. So Adam, thanks for coming back. I'll get right to it. The first question we had when we're talking about the sort of power and influence of big tech and social media giants, the question was this: why are there no major lawsuits against Facebook, Twitter, and Amazon for suppressing freedom of speech? Why wouldn't these suits ultimately go to the Supreme Court? Is there any known lawsuit against Facebook, and how can we support to ensure a win? So a lot of questions in there, but what are your thoughts?
Yeah, there's a lot packed in there for sure. The first thing to note, of course, is that private corporations, that is corporate business entities that are not chartered by the government, but are incorporated by citizens, private shareholders, are not, of course, subject to the restrictions imposed on governments by constitutions. Okay. So the First Amendment of the Constitution of the United States, for example, or provisions of state constitutions, such as the Massachusetts Constitution or the California Constitution, protecting freedom of association, freedom of speech, freedom of religion, they don't apply to Facebook, Apple, Amazon, Netflix, Google, the big tech companies.
That's because the Bill of Rights protects us from the government, whether it's federal or state, but from the government, not other private entities.
Yeah, that's right. And of course, it was grounded in the experience of the founders, which was that the most existential threats to civil liberties came from the king or the king in parliament. And so the Bill of Rights was designed to limit the powers of government.
Would have liked to see Sam Adams on Twitter, by the way, but that's another conversation.
I think it could be pretty acerbic, I'm guessing. But our legal tradition, going all the way back to England and the English common law, which we inherited at the time of the American founding, does have other important legal securities for civil rights. And these include civil rights of private property, freedom to contract, freedom to speak freely, freedom to exercise religion and to associate with other people with our shared convictions. And there are long-standing legal doctrines which prevent even private companies from infringing our civil rights. Doctrines such as antitrust doctrines, when a major market actor, particularly a monopolistic power, uses its economic power to prevent other people from entering into contracts or transacting with each other freely, which is what we're witnessing right now with Amazon,
right?
Suppressing certain books and not allowing people to purchase them.
Still got it.
That's the one. That's one of them. That's the one that got the most notoriety. Similarly, if you have a major market actor, particularly one with a monopoly market position, which uses its power to discriminate against people and to deny them access to its resources and its facilities and its premises on some illicit basis because of their race or because of their religious beliefs, that's a violation of public accommodations laws, which protects property rights. Right. Similarly, the law of defamation is there to protect free speech so that we can communicate freely and not be defamed for expressing our views by major cultural and economic powers. So there are legal doctrines in place to be used by those who wanted to pursue them for various antitrust violations, public accommodations, discrimination, and defamation being perpetrated by these big companies. And I'll note that there is a lawsuit that several state attorneys general from both Democratic and Republican states have initiated against Google just in the last few months on some of these grounds, particularly antitrust grounds.
So would Ryan Anderson, the author of that book that's been banned by Amazon, or the CEO of Parler, right, that got booted off of Amazon's web servers, which someone was telling me recently that they actually make most of their profit at this point from their web servicing. Would either of those companies or individuals have a case against, I guess in this situation, Amazon for interfering with their ability to reach their audiences or reach their market?
I think they would have a very strong case. Now, the challenge is, to a lot of people, this is going, including many judges, this is going to look like a novel claim, because what the claim would be based in those two cases would be based on the fact that Amazon is a public accommodation. It's a place of public accommodation, and we're used to thinking of places of public accommodation being like the utility company,
Yeah,
or Amtrak, or
phone company,
a
right?
hotel or a phone company, right? And that has a brick and mortar place.
Yeah.
But the same legal doctrine applies whether or not you have a brick and mortar place or a virtual place. And if you look at Amazon's market share, I don't think there could be a stronger case or a stronger example to be found of a company that is a public accommodation. It should be subject to liability for violating its public accommodation duties. When it opens up its platform to the public, it's giving a license to the public and promising we're not going to discriminate on any unlawful basis.
Okay, well, and I know Ryan Anderson, I think, wrote an article in the Wall Street Journal a day or so ago that essentially called on, and I think it's an enterprising state attorney general could have a case there. So I'll drop that in the notes. And if you can send me, maybe, I know you've got some articles, you've got a whole book, at least one, on property rights as a sort of jurisprudence legal book for most of our audience, including me. To be honest, that's probably more than we can digest practically. But if you've got some articles, maybe the public discourse or otherwise, that touch on this theme of property rights as a different way of framing it and looking at it, because as you say, the First Amendment's not going to save us from a tyrannical Amazon, so to speak. Now, speaking of the First Amendment, another question we had was, do we have separation of church and state anymore? And if so, can the church ignore the parts of the Equity Act that force priests to marry gay couples? So I know the Equity Act, or the Equality Act, I guess, is what the Equality Act is being debated in the Senate, or will be debated in the Senate soon. It's unclear how that vote will go, but there's a lot of concern, understandable concern from folks about the religious liberty implications of the Equality Act. I'm not aware, based on what I've seen and read, that it would actually force priests to marry gay couples, but what are your thoughts on the threats posed by the Equality Act? And is that scenario actually something we have to worry about, that the state could now force priests, ministers, pastors to marry people that fall outside the definition of marriage as we understand it from God's design?
Yeah, I think the general inclination for a careful lawyer like you or like me is to read the Equality Act and say, well, it's I don't think that's a reasonable interpretation that it could be taken that far. On the other hand, I think up until the day before yesterday, you would have looked at the 1964 Civil Rights Act and said, well, I don't think anyone could read this to suggest that a school district or a business which preserves separate facilities for men and women, has separate dress codes for men and women, requires women to wear tops, for example, or requires men to wear suits in certain business settings, would be violating the prohibition against discrimination on the basis of sex. But of course, the Supreme Court in the Bostock case discovered this hidden Gnostic meaning in this Civil Rights Act that was passed at a time when everybody understood that man and woman are inherently different. So unfortunately, we're at the place now where certain elites who get into cultural, economic, academic, or especially political power have demonstrated that they're willing to just disregard the law and be completely lawless and take the thinnest reed and turn it into a bullwhip. So I think it's not an unrealistic concern, frankly.
Right. And the courts have not proven to be an effective bulwark against this, with Gorsuch, right, a Trump pick, and Roberts, both weighing in on that really unfounded interpretation of sex to also include sex orientation and gender identity. And that was just last fall, I mean,
Last summer, yeah, the end of last term, yeah. So it is deeply concerning. On the other hand, I would say that I think there's a growing movement of people who are increasingly aware of how radical and dangerous this ideology is. Just in the last couple of weeks, we've seen the emergence of the detransing movement,
yeah,
which I think is a great sign. I mean, I think this is these are the sorts of groups that faithful people of conviction, whether Christian or just a matter of natural reason, ought to be paying attention to, coming alongside, encouraging people who have been harmed by the sexual revolution, who are coming out of that ideology and waking up to the reality of the created nature inherent in their bodies,
yeah.
and what this means for the way to live well. And I think that's the hope, is that faithful communities, churches, synagogues, and the rest will look for those who have been harmed by the sexual revolution, will maintain their faithful witness about what it means to be man and woman, what it means to be married, what it means to have these rights for the benefit of children and the next generation,
Right.
even if it gets difficult in the days ahead.
Yeah, nature has a way of reasserting itself, thank goodness, against some of this craziness. And the left tends to just overextend itself. And so there should be a pushback, but irreparable, potentially harm done in the interim. Last question, and it's sort of more a practical one. Help us to understand how to make a positive case for our refusal to live by lies when we must confront the lies. For example, telling the group or human resources person why we can't participate in the meeting where speech is forced and the truth cannot be spoken. And I was just hearing from someone this morning who's at a local college and was lamenting the fact that they and many of their colleagues had to sit through all this CRT training and just kind of take it. What are your thoughts on that? How can we, is there special legal language we should use when we're confronted with one of these potential violations of conscience or compelled speech in an HR employment environment?
Yeah, well, of course, the legal basis would be grounded in things like religious freedom, freedom of speech, not being compelled to say something that one believes to be false. You know, this Supreme Court's famous case in West Virginia versus Barnett, where the Supreme Court said, even for good reasons of patriotism and defeating the Nazi enemy during World War II, it's still not justifiable to compel religious dissenters to say the Pledge of Allegiance, for example.
Right.
This is a foundational principle of American constitutionalism and American jurisprudence. Practically speaking, as a matter of prudentially or strategically how to deal with those situations, I find it's most effective in those situations to articulate what one is for rather than what one is against. And so this is, again, it underscores the imperative that faithful people understand what marriage is and what it's good for the flourishing of children, for the edification of the man and the woman. They understand what it means to be created in the image of God as male and female, and be able to articulate that winsomely and courageously is difficult. But I think it's increasingly important. And, I've found often when you speak the truth clearly, a lot of people get angry. But I've also found a lot of people are listening. They don't always indicate that they're listening at the time. Sometimes they come up to you afterward and whisper, "Thanks for saying that." But ultimately, that's our calling, because we know what it means to be a human being created in the image of God, and that's what we're called to communicate.
Yeah, that's true. I so often, even from my early days of, I guess, activism in law school, when I did some pro-life things and at a very liberal law school where they were celebrating the birthday of abortion, of Roe v. Wade, sort of a twisted irony there. But there were students who came up to me when I was wearing a pro-life t-shirt one day to class and just sort of thanked me. And that was the main response I got. There weren't really, I didn't get beat up or spat on or anything like that. So you just never know how many people are out there that agree with you, agree with the truth, but are just terrified to say anything. And when I get people who call my office with these situations in an employment context, we typically start from the premise of, well, can you request a reasonable accommodation? Is it a reasonable accommodation for your employer to say, okay, you don't have to use the preferred pronouns? We haven't really seen that litigated, that specific topic, much. I think there was one case out of Virginia that maybe didn't go that well, but it was in a public school context. There was different dynamics there. But I think in a general employment environment, it should be hard for an employer to say that, no, it's unreasonable to permit an employee to either not use pronouns or, not use preferred pronouns. So we've yet to see, but that's kind of, you can always request that, and then they have to answer that, and you get that in writing. And so I've seen that work. When you put it in writing, they know it's from an attorney. You're requesting a reasonable accommodation, and I think it's kind of hard for them to say that it's unreasonable to just not be forced to say words that you believe are untrue.
No, I think that's right. And there certainly are legal strategies available, like the reasonable accommodation in the employment context. For religious entities, of course, it's a matter of framing your policies and framing your practices such that your employees understand that they're ministers of your religious tradition, of the gospel, if you're a Christian organization. And therefore the assembly, the group, the religious company or nonprofit is itself entitled to certain religious liberty protections under state and federal law. So it's always important, of course, to consult lawyers, and there are some great ones focused on the particular technical legal doctrines that can be employed.
Some groups that'll do it pro bono, so you don't have to have a big retainer fee or something like that. So you can always reach out to me at mafamily.org, and we can put you in touch with people who can help, and oftentimes do it pro bono, which is a big deal.
Yeah.
So, well, thanks so much for your time, Adam. I appreciate you helping me follow up and make good on my promise to try and answer those questions that people put in the Q&A section of the Zoom on Tuesday night. I'm going to get this up online as soon as I can and sent out to our audience. Thanks again, and we'll talk to you soon.
Thanks for having me, Andrew.